Should I accept an insurance company's first offer? 2 days after your crash, an all smiles insurance adjuster calls and dangles a settlement check. Right now, no strings attached, no questions asked. Grab that quick cash and you could be signing away tens and thousands of dollars you'll need for surgery, therapy, and months of lost pay. Stay with me and you'll learn exactly why that first offer is a trap and the must-do moves that lock in every dollar the laws in Florida allow you to cover for your injuries from a vehicle accident. Hi, I'm Pablo Tamayo. I've been a practicing lawyer in the state of Florida for 2 decades, almost 20 years now. And today, I want to walk you through exactly why insurance companies make these quick offers, what you should and shouldn't do when they contact you, and how to protect yourself from making costly mistakes that could affect your recovery from years to come. Now let's discuss why insurance companies rush to make these first offers. Insurance companies are businesses, and their primary goal is to minimize their financial exposure. When they make you a quick settlement offer, they're banking on several things. First, they know you're dealing with medical bills, lost wages, and financial stress. They're hoping you'll see that check as a lifeline and grab it without thinking about the long-term consequences. Second, they know that most people don't understand the true value of their claim. You might think your case is just about your car repairs, maybe a few medical bills. But in Florida, you could be entitled to compensation for past and future medical expenses, lost wages, pain and suffering, mental anguish, and in some cases, even punitive damages. Third, and this one's crucial, they know that once you accept their offer and sign that release, you're done. Can't come back later when you realize your injuries are more serious than you initially thought and you need extensive treatment. Or when complications develop months down the road with your injuries. I've seen countless cases where someone accepted a quick settlement offer for a few $1,000s, only to discover later that their back injury requires surgery or their concussion symptoms persist for months and lead to cognitive loss. Or they develop some sort of post-traumatic stress disorder that affects their ability to work and their ability to be a father or a mother at home. In Florida, once you've cashed that check and signed the release, you cannot just reopen your claim to add on your additional treatment for your more significant injuries. Once it's done forever. So let's understand Florida's insurance landscape. Florida operates under a no-fault insurance system, which means your own personal injury protection, or PIP, pays for your initial medical expenses and lost wages, regardless of who caused the accident. But PIP only covers 80% of your medical bills and 60% of your lost wages, up to your policy limits, which for most people in Florida is $10,000. When your injuries exceed what PIP covers, or when you meet Florida's serious injury threshold under Florida Statute 627.737, you can pursue a claim against the at-fault driver's insurance company for economic and non-economic damages. This is where things get a little bit complicated, and this is exactly where insurance companies try and take advantage. The serious injury threshold in Florida includes permanent injury, significant and permanent scarring or disfigurement, or significant and permanent loss of an important bodily function. What many people don't realize, though, is that even non-catastrophic injuries can qualify under this threshold, especially when they result in ongoing pain or functional limitations. That may not include a loss of limb or a broken bone. Let's talk about the problems with first offers. Let me tell you about a case that illustrates this perfectly. I had a client who was rear-ended at a red light. She felt sore, but thought, for the most part, she would be okay. The insurance company called her 3 days later and offered her $2,500 to settle her case. She was tempted to take it because she thought her injuries were not that significant at the time, and quite frankly, she could use that $2,500. Fortunately, she called me first. She was given a proper medical evaluation, and it turned out that she had 2 herniated discs in her cervical spine. She ended up needing months of physical therapy and ultimately required epidural injections for her pain. Her case eventually settled for $45,000. If she would have accepted that first offer, she would have given up more than $42,000 in compensation she was legally entitled to. Now, this happens because insurance adjusters make their first offers before they have the complete information on your injuries, your medical treatment, the full impact that the accident has had in your life. They're hoping you take a quick buck before speaking to an attorney for a proper evaluation of your case. Why you should never sign documents from the insurance company. When the insurance company sends you a check directly, they're going to send you paperwork along with it. They'll call it a release or a settlement agreement, and they'll make it sound routine and harmless. Do not sign anything without having an attorney review it first. These documents are legally binding contracts that typically include broad release language. What this means is that by signing, you're not just releasing them from liability for your current known injuries, you're also releasing them from liability from any and all claims related to the accident, including future complications, undiscovered injuries, and sometimes even claims you haven't even thought of yet. Under Florida law, once you sign a release, you're legally bound by its terms. I've seen releases that include language releasing the insurance company from liability for any family members' claims, future medical complications, loss of consortium claims from your spouse, and even claims for punitive damages. The moral of the story is don't go at it alone. Speak to an attorney before you sign any insurance documentation. A question that comes up a lot in my practice is, should you give a statement to the insurance adjuster? This is one of the most important decisions you'll make in your case. And unfortunately, it's one that many people get wrong. The insurance adjuster will call you and say they need to get your statement about what happened. They'll make it sound mandatory, routine, and harmless. They might even say they can't process your claim without it. Here's what you need to know. In most cases, you are not legally required to give a statement to the other party's insurance company. You have the right to refuse, and you have the right to have an attorney present if you do decide to give a statement. Why does this matter? Because that statement can be used against you later. Insurance adjusters are trained to ask questions that might get you to say things that could hurt your case. They might ask you about your medical history, and if you forget to mention an old injury, no matter how old that was, even if it was 10, 15 years ago, they'll use that to argue that your current problems are pre-existing and that they didn't result from your accident. Recorded statements that you make to insurance adjusters may also be admissible in court as admissions against your interest. This means that anything you say can potentially be used against you if your case goes to trial. So be careful if the adjuster for the other driver calls you shortly after the accident. I'm not saying they're bad people, they're just doing their job, but they certainly are not your friend. The importance of understanding your medical treatment. One of the biggest mistakes I see people make is settling their claims before they understand the full extent of their injuries and their treatment needs. In Florida, you're entitled to compensation for all reasonable and necessary medical expenses related to your accident, both in the past and in the future. But here's the thing. Some injuries don't show up right away. Herniated discs, traumatic brain injuries, and soft tissue injuries, and those symptoms related to those injuries can take days, weeks, or even actually months to fully manifest. If you settle your claim before you've reached what doctors call maximum medical improvement, otherwise known as MMI, you're essentially gambling with your future health and financial security. Florida allows you to recover damages for future medical expenses, but only if you can prove they're reasonably certain to be incurred. This requires proper medical documentation and often expert testimony. If you've already settled your claim, you've given up this right forever. And what about property damage? Many people think they can settle their property damage claim separately from their injury claim. And while it is true that they are separate claims, you need to be careful about what you're signing when it comes to your property damage claim. Some release forms from insurance companies may try to settle everything at once, including both property damage and a personal injury claim. In Florida, you generally can settle your property damage claim without affecting your personal injury claim, as long as the release that you sign is specifically limited to the property damage for your vehicle. Sometimes, insurance companies may try to sneak in broader language into these releases, so later they can make an argument that they also settled your personal injury claim. So, it's important to read everything carefully. The real cost of accepting quick settlements. Let me give you some perspective on what you might be giving up when you accept a quick settlement. In Florida, you are potentially entitled to compensation for medical expenses, lost wages, pain and suffering, mental anguish, loss of capacity for the enjoyment of life, and in some more rare cases, even punitive damages, which just means penalties, essentially. Pain and suffering damages alone can be substantial. Florida courts have recognized that even non-catastrophic injuries can result in significant pain and suffering. Lost wages aren't just about the time you've missed from work. If your injuries affect your ability to work in the future, you could also be entitled to compensation for your loss of future earning capacity. This is particularly important if you're young or if you work in a physical job that your injuries might prevent you or restrict you from performing the same way. When insurance companies use tactics against you, insurance companies have a bag of tricks they use to try and get people to settle quickly and for less than their claims are worth. They might tell you that if you don't accept their offer now, it won't be available later. This is almost always false. They might tell you that you don't need an attorney, that hiring one will just delay your case and cost you money. This is also very misleading. They might even try to convince you that your case isn't worth much because in Florida, it's a no-fault state. While it is true that Florida has no-fault insurance, this has nothing to do with your claim against an at-fault driver that has caused you injuries. The role of medical records in your case. Your medical records are the foundation of your personal injury case. Insurance companies know this, which is why they often try to settle cases before you've had a chance to fully document the full extent of your injuries. They're hoping to settle your claim before you've seen specialists, before you've had necessary diagnostic tests, and before you fully understand the impact your injuries will have on your future life. In Florida, you have the right to see appropriate medical providers and to get the treatment that you need. The insurance company doesn't get to dictate your medical care or tell you that certain treatments aren't necessary. If your doctor recommends treatment and it's reasonable and related to the accident, you should generally follow the doctor's advice. So what should you do if an insurance company contacts you? First, always be polite but firm. You don't have to be rude, but you also don't have to provide detailed information about every question that they ask. You don't have to accept their first offer either. You can simply tell them that you're still receiving medical treatment and that you'll be in touch when you understand the full extent of your injuries. Second, don't sign anything without having it reviewed by an attorney. Even if the insurance company tells you it's just a formality or that it's standard paperwork, have someone who understands these documents look at them first. Third, document everything. Keep records of all your medical treatment, all your conversations with insurance adjusters, or at least notes and dates that you spoke with them, and all the ways your injuries have affected your life. This documentation will be crucial if you decide to pursue a claim later. Why this matters for your future? The decisions you make in the days and weeks after your accident can affect your financial security and your quality of life for years to come. I've seen too many people who accepted quick settlements only to regret it later, when their injuries required ongoing treatment or when they'd realized they'd given up valuable rights. Remember, the insurance company's interests are directly opposed to yours. They want to pay you as little as possible, as quickly as possible. You want to make sure that you receive fair compensation for all the ways the accident has impacted your life. The most important thing you can do after an accident is to arm yourself with knowledge. Understand your rights, understand the process, and don't let anyone pressure you into making decisions that you're not ready. The insurance company's urgency is artificial. There's no real deadline that requires you to accept their first offer. You just learn why insurance companies make quick settlement offers, why you should be extremely cautious about signing their documents, and why giving them a statement without proper preparation can hurt your case. This knowledge puts you in a much stronger position to protect your interests and make decisions that are right for your situation. But knowing what not to do is only half the battle. What you do immediately after an accident is just as important as what you don't do. The steps you take in those first critical hours and days can make or break your case. And there are 5 specific things that every accident victim in Florida absolutely must do to protect their rights and maximize their recovery. I'm going to cover all 5 of these essential steps in my next video. 5 things you must do immediately after a Florida car accident. These aren't just helpful suggestions, they're necessities that could mean the difference between a successful claim and a denied one or an undervalued one. If you don't take these steps, you could be leaving money on the table, or worse, you could be giving the insurance company ammunition to use against you later to try and deny your claim. Don't let another day go by without understanding exactly what you need to do to protect you and your family. I'll see you over there.